I never imagined the day I would stand in a courtroom and watch my own son's hands be handcuffed behind his back. Those same hands I had guided around a hockey stick in our driveway in Sudbury when he was 6 years old, cheering every time he made contact with the puck. That image, little boy, red mittens, enormous smile, played on a loop in my mind as the officer clicked the cuffs into place. I had to look away. My name is not important. What matters is that I am 63 years old. I worked 31 years as a structural engineer for the same firm in Ontario. I buried my wife 8 years ago and last spring. My son threatened to have me declared mentally incompetent if I did not give him $120,000. Let me back up. My wife, Sandra, passed from pancreatic cancer in 2016. It was fast, 4 months from diagnosis to the end. Our son, who I will call by his name, Ryan, no wait. His name is not Ryan, his name is Callum. Callum Edward Marsh. I want to use his real name because I am done protecting him. He was 24 when his mother died. I was 55. We grieved differently. I went quiet. He went angry. I understood that at first. I sold our family home in Sudbury 2 years after Sandra passed. It was too big, too full of her, and I could not walk past the kitchen without hearing her laugh. I moved to a 2-bedroom condo in Barrie, modest, clean, close enough to the lake that I could see the water from my balcony on clear mornings. It cost me $380,000. I paid cash. The rest of the proceeds from the Sudbury house, plus my investments and pension savings, sat in accounts that I managed carefully. I had also inherited a small rental property in Collingwood from my own father, a 4-unit building that generated steady income each month. Nothing extravagant. Comfortable, earned. Callum knew about the condo. He did not know the full picture of everything else. For years after Sandra died, Callum and I had a decent relationship. Not warm exactly. He had always been more his mother's child, and without her as the bridge between us, we were a little awkward with each other. We talked on the phone every few weeks. He came for Christmas. We watched hockey together. It was fine. Not close, but fine. Then he met Brianna. I want to be fair about Brianna, because I think she is more complicated than she appeared to me in those months. She is not a stupid woman. She is not even a cruel woman necessarily, but she had very particular ideas about what kind of life she deserved, and those ideas required money that neither she nor my son had. They met at a work conference in Toronto. Callum was in sales for a software company. Brianna was in marketing. Within 6 weeks, they were living together in her apartment in the annex. Within 4 months, Callum called to tell me they were engaged. 4 months. I said congratulations. I said I was happy for him. I meant it, as much as I could mean it for someone I had met exactly once, at a birthday dinner where she spent most of the meal talking about a trip to Portugal she had taken the previous summer. I kept an open mind. Sandra would have told me to keep an open mind. The first conversation about money came in February, about 3 months after the engagement announcement. Callum called on a Sunday evening. I remember because I had just finished watching the Leafs lose, which put me in a particular kind of mood. He said they had been looking at venues. He said Brianna had always dreamed of a real wedding, the kind with a proper reception hall, a live band, flowers, the whole thing. He mentioned a venue in Muskoka that had caught their eye. I asked what that kind of wedding cost. He said the venue alone was $42,000, and that was before catering, photographer, dress, invitations, hotel blocks for guests. He said all in, they were probably looking at $90,000 to $100,000. I set down my cup of tea. I told him that was a substantial amount of money. I told him I thought that was something he and Brianna should plan around what they could afford, not around what they imagined might be available from elsewhere. I said this gently. I was careful. He said he understood that, but he also said, and I remember this precisely, "Dad, you have the money. We both know you do." I told him I was not prepared to commit to that kind of figure. I said I would be happy to give a gift for the wedding, something meaningful, but that $100,000 was not a gift. That was a transfer of retirement savings. He did not argue. He said okay, and we changed the subject. I thought the matter was settled. It was not settled. In March, Brianna called me directly. I did not know she had my number. She was pleasant, warm even, and she asked if she could take me to lunch the next time I was in Toronto. I said of course. We met at a restaurant near King Street. Her choice, not inexpensive. She ordered a glass of wine at noon and talked about how much she loved Callum, how she had never met anyone like him, how she just wanted their beginning together to be something they would remember forever. She said her own parents had contributed $20,000, which was all they could manage. She said her father had health issues, and they were not in a strong financial position. Then she said, "I know Callum's mother left quite a bit behind. It must be sitting there in some account. I just think Sandra would have wanted her son's wedding to be beautiful." I looked at her across the table. She smiled. It was a practiced smile. I told her Sandra's estate had been settled years ago and that it had covered the costs associated with her illness and funeral. This was not entirely true. There had been a life insurance policy, but I was not about to inventory my finances for my son's girlfriend of 4 months over a $12 glass of Chardonnay. I drove home to Barrie feeling unsettled in a way I could not quite name. The calls escalated through spring. First Callum, then Brianna, then both of them together on speakerphone one evening in April, tag-teaming me with a revised budget they had put together. They had scaled back, they said. Not 100,000, just 60. They could finance the rest themselves if I contributed 60,000. I said no. Callum's voice changed when I said it. Not immediately. There was a pause first, the kind of pause where someone is deciding something. Then he said, "Dad, I think you need to think seriously about what this says about how you see our relationship." I told him it said nothing about our relationship. It said that I was a 63-year-old man on a fixed income from a pension and I had to be careful. He said, "You're not on a fixed income. You have that building in Collingwood." I had never told him about the Collingwood property. I asked him how he knew about that. He said he had talked to my cousin Deborah at Christmas and she had mentioned it. Deborah is Sandra's cousin, and she had known my father before he died and apparently had talked at some point about the inheritance. I felt something cold move through me then. Not anger, exactly. Something more like clarity. I told Callum I needed to go and I would call him later. I hung up. I sat on my balcony for a long time that evening, watching the light change over Kempenfeld Bay. I thought about Sandra. I thought about what she would have said. Sandra was not a soft person. She was kind, but she was clear-eyed, and she would have told me to trust what I was feeling. What I was feeling was that something had shifted, that I was no longer being asked. I was being assessed. May was quiet, too quiet. Callum barely called. When he did, he was brief and oddly formal, like someone who was waiting for something. The something arrived in June. I received a letter, an actual printed letter sent by registered mail from a law firm in Toronto. It was addressed to me by full name. It stated that my son Callum Edward Marsh had retained their services and was prepared to initiate an application under the Substitute Decisions Act for an assessment of my capacity to manage property, citing concerns about my judgment and potential cognitive decline. I read it 3 times. Then I sat very still for a very long time. The letter did not make an explicit demand. It did not say, "Give us the money or we file." But it also did not have to. The implication was unmistakable. If I did not cooperate with what exactly was left strategically vague, they would pursue legal proceedings to have my financial decision-making capacity evaluated. Let me tell you what that means in Ontario. A capacity assessment under the Substitute Decisions Act is not a trivial thing. If a person is found incapable of managing property, a guardian can be appointed. That guardian makes financial decisions on their behalf. It can take months or years of legal battle to overturn. And the process itself, the assessment, the hearings, the stigma, is devastating even when you win. Callum was betting that I would be afraid enough to pay. He was right that I was afraid. He was wrong about what that fear would make me do. I called my own lawyer the next morning. Her name is Gwen. I have worked with her for 15 years, since Sandra and I first updated our wills after my father died. I drove to her office in Barrie that same afternoon and sat across from her desk and slid the letter across to her. She read it carefully. She set it down. She looked at me. She said, "Walter, do not give them a cent." I said I had no intention of it. Then she said, "I need you to understand something. This letter is aggressive, but it is also legally thin. Refusing to fund your adult child's wedding is not evidence of cognitive decline, not even close. If they file, we respond, and we document everything." We spent 2 hours that afternoon going through every interaction I could remember. The calls, the lunch with Brianna, the speakerphone call, the question about Collingwood. Gwen took detailed notes. She asked me to go home and write down everything I could recall with dates and send it to her. She also told me something I had not considered, that making a deliberate financial threat of this nature, using legal proceedings as leverage to extract money, had its own legal consequences. I drove home and wrote for 4 hours. I filled 11 pages. What I did not tell Callum or Brianna, and what I had been careful not to tell anyone outside of Gwen and my accountant, was that I had spent the 2 years since Sandra's death making very deliberate financial arrangements. The Collingwood property was held in a family trust. My investment accounts had beneficiary designations. My pension survivor provisions were in order. Everything was structured. Everything was documented. I was not a confused old man sitting on a pile of unsecured cash. I was a retired structural engineer who had spent 3 decades building things that held up under load. I applied the same discipline to my finances. There was nothing to seize. There was nothing to appoint a guardian over. The letter was a bluff. But bluffs can still do damage, and I was still his father. In July, I called Callum, not to negotiate. I want to be clear about that. I called because I needed to hear his voice and try to understand what had happened to the person I had raised. He answered on the second ring and sounded almost surprised to hear from me. I told him I had received the letter from his lawyer. Silence. I told him I was not going to give him the money. I told him that no version of this, no modified budget, no scaled-back venue, no revised timeline, was going to end with me writing a check for $60 or $80 or $100,000 in response to a legal threat. I told him if he wanted to have a conversation about a reasonable wedding gift, $5,000, $10,000, something within what I considered a genuine contribution, I was open to that, but that conversation could only happen after the lawyer's letter was formally withdrawn. He said, "Dad, you don't understand what we're dealing with. We have deposits down. We have commitments." I asked him when they had put deposits down. He didn't answer. I asked again. He said January. They had put deposits down in January. When I had said no in February, they had already committed to the venue. They had gambled that I would fold. I told him I was sorry he had made commitments without confirming the funding. I told him that was a decision he and Brianna had made, and it was not one I was responsible for. He said something then that I have not repeated to anyone outside of Gwen's office. I will not repeat it here either. What I will say is that it involved a suggestion about how I had treated Sandra during her illness, a suggestion that was not only false but was the single most deliberately cruel thing anyone has ever said to me in 63 years of living. I heard it, and I felt something go very quiet inside me. Not rage. Quieter than rage. I told him I was going to hang up now. I told him I loved him, and I hung up. I did not hear from him for 6 weeks. What I did hear from in August, forwarded to Gwen by the opposing law firm, was a notification that they intended to proceed with the capacity assessment application. They had found a physician, they said, who had agreed to conduct an initial evaluation based on a sworn statement from Callum describing my erratic behavior and apparent confusion about financial obligations. A physician, based on a statement from my son who had not seen me in 8 months. Gwen filed a response within 48 hours. The response included the 11 pages I had written in June, notarized. It included a letter from my own physician, Dr. Partin. Anand, who had been my GP for 12 years and who stated in clinical terms that I was in full cognitive health with no indicators of impaired decision-making. It included statements from my accountant and from the trust company that administered the Collingwood property, demonstrating that my financial affairs were meticulously organized and actively managed. It also included something Gwen had suggested and I had agreed to, a formal complaint to the Law Society of Ontario regarding the conduct of Callum's lawyer in using capacity legislation as leverage in a financial dispute between family members. That complaint, Gwen told me, had a name. It was called abuse of process. 3 weeks later, Callum's lawyer withdrew from the file. I found out later, through Deborah, who had heard it from Brianna's mother, that the lawyer had told them he could not continue to advance a capacity claim that had no clinical foundation, and that doing so exposed him to professional sanction. He apparently also told them that the sworn statement Callum had filed constituted a serious document, one that would remain on record, and that they should think carefully about their next steps. Their next steps, it turned out, involved Brianna. What none of us had known, not me, not Callum, apparently not even most of Brianna's friends, was that Brianna had been conducting a parallel scheme for several months that had nothing to do with the wedding. She had been using Callum's identity, including his credit information and his signature on documents he had signed without reading carefully, to take out 2 personal lines of credit and a secured loan against a vehicle that Callum believed was paid off. The total was approximately $78,000. The money had gone toward what investigators would later describe as a combination of personal debt consolidation, online investment fraud she had fallen into, and what appeared to be a gambling pattern she had been concealing for years. Callum had not known. I want to be precise about this, because I have thought about it a great deal. I do not believe Callum knew about Brianna's financial crimes. I believe he was, in his own way, also being manipulated, that she had persuaded him the wedding money was essential because she needed the cash flow, and that the pressure campaign against me was her strategy, not entirely his. This does not excuse what he said to me in July. It does not excuse the lawyer's letter. He made choices. He participated, but he was not, I think, the architect. The investigation into Brianna began when one of the creditors flagged the loan irregularities to a fraud unit. It was the vehicle loan. Callum's car had been used as collateral without his knowledge, and when the registration was cross-checked, the signatures did not match the ones on file. A financial crimes investigator contacted Callum in September. He cooperated fully. He had to. The documentation trail led directly through accounts that bore his name. Brianna was charged in October. Fraud over $5,000, identity theft, forgery. Her lawyer negotiated a process that would take months, but the charges were real and they were serious. The wedding, needless to say, did not happen. Callum called me the evening after Brianna was charged. He had been crying. I could hear it in his voice, even though he was trying to hold it together. He did not ask for money. He did not say much of anything coherent at first. He just said, "Dad, I'm sorry." I did not say it was fine. It was not fine. I told him I heard him. I told him to find himself a good lawyer for the identity theft proceedings because his own exposure needed to be managed carefully. I told him I would pay for the lawyer, not because I owed it to him, because he is my son and he was in trouble, and Sandra is not here to tell me what the right thing is, so I have to figure it out myself. He came to Barry the following weekend. He slept in the second bedroom for 2 nights. We did not talk about Brianna much. We watched hockey. I made the pasta Sandra used to make, the one with Italian sausage and fennel that she had learned from a woman at our parish. He had 2 helpings. On the second morning, over coffee on the balcony, he asked me how I had known. How I had known to get a lawyer immediately, to document everything, to not be rattled by the capacity letter. I told him I was a structural engineer for 31 years. I told him I knew what a load-bearing wall looked like, and I knew what a bluff looked like, and I had learned to tell the difference. He was quiet for a while, looking out at the bay. Then he said, "I should have trusted you." I told him yes, he should have. The criminal proceedings against Brianna concluded 14 months later. She received a conditional sentence and restitution order. Callum was formally cleared of any involvement. His credit took time to repair, but he did the work. He moved into a smaller apartment, took on a second project contract, and started treating money the way I had tried to teach him to treat it when he was young, which is to say, with respect, not as a quantity to be conjured from someone else's account. I did eventually give him a gift. Not 60,000, not even 10. I gave him the hockey stick, the old one, the wooden one, the one from the driveway in Sudbury. I had kept it in the storage locker at the condo, wrapped in an old flannel shirt of Sandra's. I had no reason to keep it except that I could not make myself get rid of it. He held it for a long time without saying anything. Some things do not need to be said. We both understood what it meant, that there was still something to come back to, that the hands that had held that stick were still, underneath everything, his father's hands, that I had not stopped being his father, even when he had nearly stopped being my son. I do not know what the next years will look like. I know I still get up every morning and make coffee and stand on my balcony and look at the water. I know that I am 63 years old and I worked hard and I made careful choices, and no one, not a law firm, not a daughter-in-law, not a letter sent by registered mail, was going to take that from me without a fight. And I know that on a Sunday morning last March, my son drove up from Toronto with a bag of groceries and made breakfast while I sat at the kitchen table and read the paper, and for 1 hour it felt, not like before, but like the beginning of something that might, with time and honesty and a great deal of patience, become something worth having. That was enough for one morning. It had to be. I still have the 11 pages I wrote that night in June. They sit in a folder in my filing cabinet next to Sandra's medical records and the deed to the Collingwood property. I don't know why I keep them. Maybe because they remind me that there was a moment when I had to choose between being frightened and being clear, and I chose to be clear. That's not a small thing. I've thought about it a lot over the past year, about how easy it would have been to write the check. Not because I believed I owed it, but because the alternative felt so enormous and so exhausting. 63 years old, no partner, a son I didn't want to lose, a legal letter on my kitchen table. The path of least resistance was right there. A transfer, a number, done. But I've spent my whole career understanding load-bearing structures. I know what holds and what doesn't, and I knew I could feel it the way you feel a flaw in a weld before you see it, that giving in would not end anything. It would only confirm that the pressure worked. And pressure that works gets applied again. What Callum did came from a place of weakness, not cruelty. That's the part I had to sit with for a long time, and the part I'm still sitting with. He made choices that were wrong, genuinely wrong, not just inconvenient for me, but dishonest and damaging. And he made them because he had let someone else's panic become his own? That's not an excuse. A grown man is responsible for what he signs his name to, what he says to his father in anger, what he allows to happen under his roof. He knows that now. I think he knew it then too. Sometimes people do things they know are wrong because they've lost the steadiness to do otherwise. Steadiness is something you build. It doesn't arrive. I watched my father build it over decades of small, consistent decisions, paying what he owed, saying what he meant, not borrowing against the future to cover the present. I tried to pass that on to Callum, and for a period of about 8 months, it didn't hold. But the foundation was still there underneath. That's the only reason we're having breakfast together now instead of speaking through lawyers. The thing about integrity, about actually doing the right thing when the wrong thing is cheaper and faster and available, is that it costs something in the short term. Always. Gwen's fees were not nothing. The months of silence from my son were not nothing. Standing in my condo reading that registered letter and feeling my hands go cold was not nothing. The right path and the easy path are almost never the same road. And intelligence isn't just knowing the law or knowing your rights or having a good accountant, though all of those helped. It's knowing yourself well enough to recognize when you're being tested and not to pretend you aren't. I was frightened. I admitted that to myself sitting on that balcony in June watching the light go off, Kempenfeld Bay, admitting it was the first step toward doing something useful with it. What I hope, more than anything, is that Callum took something from this that lasts longer than the embarrassment, not the lesson that his father won. I don't want him to remember it that way. I want him to remember that the choices we make about money, about honesty, about how we treat the people who love us, accumulate over time into something we have to live inside. The way Brianna's choices accumulated. The way mine did too, in the other direction. I gave him the hockey stick. He understood what I meant by it. That's enough for now.